Having considered the testimony here today, I'm going to start with section 90.702, which is testimony by experts, is the codification of the Daubert standard. Just a preliminary matter, this is a situation where scientific, technical, or other specialized knowledge will assist the trier of fact. These are very complicated issues. Experts are required. And so that portion of the statute is satisfied. And then as far as whether Dr. Oleske is qualified by knowledge, skill, experience, training, or education, certainly she listed her qualifications here. She is our chief medical examiner, has been for several years. She has the requisite schooling. I think it was 13 years, if I remember correctly, of training to be a medical examiner, a forensic pathologist. She's also conducted over 2,000 post-mortem examinations. And so as a general matter, and I think the defense would even concede this, she is qualified to testify regarding cause and manner of death. The defense argument, though, is she can't make the ultimate conclusion in this case because she's not a toxicologist and she did not reliably come to her conclusion. But in general, I think they would agree she can talk about cause and manner of death in most cases. So in this case, she can testify in the form of an opinion if three things are present. Number one, the testimony is based upon sufficient facts or data. Number two, the testimony is the product of reliable principles and methods. And number three, the witness has applied the principles and methods reliably to the facts of the case. There are several opinions that I read before coming into court today just to make sure that I had the proper framework in mind as I was listening to the testimony. One is Williams versus Leesburg Regional Medical Center, Inc., 430 Southern 3rd 961, out of the 5th DCA in 2026. This stands for several propositions, but I liked it just because it kind of gave the overview that the proponent bears the burden of establishing the admissibility. Also talks about first determining whether the individual qualifies as an expert, and then what is being determined in terms of reliability. I quoted this opinion earlier when I was making a ruling to allow the defense expert to testify, that reliability is determined by examining the expert's underlying methodology rather than his or her ultimate opinion, and there were non-exhaustive factors that I quoted earlier. I also think this case is important because it sets forth the careful balance required by the trial court's gatekeeping role. On one hand, the court must ensure expert testimony employs in the courtroom the same level of intellectual rigor that characterizes the practice of an expert in the relevant field. On the other hand, it must allow the adversarial system to address any shakiness in otherwise admissible testimony. Exclusion of the testimony is the exception rather than the rule. Nothing prevents a trial court, however, from excluding expert testimony when there is simply too great an analytical gap between the data and the opinion proffered. The state mentioned the Huck case, which is one of the cases I read. I think I first came across it in Cardona versus State, 299 Southern 3rd 1142 out of the 3rd DCA in 2020, where it says a medical examiner may even render a cause of death opinion that was reached by a process of elimination of other possible causes. And there's a citation to Huck. Huck itself is at 881 Southern 2nd 1137 out of the 5th DCA in 2004. So a somewhat older opinion, but was quoted as recently, or cited as recently as 2020. And that case says that a medical expert may properly render an opinion as to cause of death by process of elimination. In that case, the medical examiner testified about the internal examination of the victim's brain, heart, and abdominal areas, and he observed no evidence of any disease or condition that would support a medical cause of death. There were specific medical causes that were mentioned on cross-examination. The medical examiner conceded that such causes undetectable by autopsy were possible but not likely, given the victim's age, health, and lack of medical history. I'll go into the facts of this case in a moment, but certainly we know in this case Dr. Oleske was not able to analyze every organ because the victim was an organ donor, but there were areas she was able to analyze. And she also mentioned that there are other possibilities, although she said unlikely, due to various things she testified about. And so in the Huck case, you had a qualified pathologist conducting a thorough autopsy and by a process of elimination concluded, based on a reasonable medical certainty, that the deceased died from suffocation or strangulation. The expert found no evidence of disease, trauma to the body, obstruction to the throat, drugs, insect, or snake bites. And so that sounds very similar to what we've heard here today. This case says a medical witness may reach a conclusion by the process of elimination through excluding natural causes of death. This process of elimination will not render the witness's conclusion inadmissible, but merely affects the weight to be given his testimony, which must be determined by the jury. Now, that is actually all a quote from the Early case out of the 3rd DCA in 1978. The Huck court was quoting the Early court. And so the Huck court ultimately determined that there is nothing inherently wrong with coming to a conclusion by use of the process of elimination. There was no error in the trial court's determination to allow the medical examiner to testify on that basis. And it says the weight to be given to such testimony and its believability are for the jury to decide. Another case that I looked at before coming in here today is the one referenced by the defense, Hawkins v. State, 933 Southern 2nd, 1186, out of the 4th DCA 2006. I do note this is under the Fry standard, not the Daubert standard, but I do still think it's worth considering seeing how it applies or doesn't apply to this case. The medical examiner in that case had conducted thousands of autopsies, similar to Dr. Oleske, but had never conducted one where the cause of death was systemic silicone embolism. That medical examiner also conceded that she was not an expert regarding the mechanism or speed that silicone migrates through the body. That expert also did not review any literature regarding the effects of silicone on the body prior to drafting the autopsy report. At trial, the medical examiner could point to nothing to support the conclusion that an injection of liquid silicone could migrate through the vascular system as quickly as would have been necessary for the silicone injection to have caused the decedent's death. So in that list of shortcomings of that expert, I think there are some that could be lodged against Dr. Oleske, and there are some that cannot. Dr. Oleske conceded she is not a toxicologist. She did, however, review literature regarding the use of lidocaine in various cosmetic procedures, how things can go wrong. She not only reviewed a textbook, but other sources. She also went to a seminar, talked to this person, the doctor who gave the seminar afterwards. She consulted a neuropathologist. She consulted toxicologists. That's a far cry from the medical examiner in Hawkins, who didn't read any literature regarding the effects of silicone on the body. As far as that medical examiner not being able to point to anything about how the injection of liquid silicone could migrate so quickly, I think that's where, Dr. Oleske's use of the phrase clinical diagnosis that frustrated the defense. She at one point testified that when she's talking about a clinical diagnosis, she's talking about a constellation of symptoms that are observed, not necessarily based on just a blood level. And so her testimony was that there was a constellation of symptoms that does support that this death was the result of complications from lidocaine toxicity. Some of the ones that she mentioned, just off the top of my head: vision changes, seeing orange, I think, blurriness, muscle twitching, restlessness, seizure. And so she is able to point to something to support her conclusion. Now, I recognize the defense expert disagrees with it, but it's not that Dr. Oleske has nothing to point to. So I don't think that this is as on all fours with Hawkins as the defense would argue. And with that, I'm going to turn to the testimony. And again, it was a very long hearing, absent our break and starting a few minutes after 9. I don't recall how long the Nelson hearing took, but we've been going at this since a little after 9 this morning. It's now after 1:30, so I will do my best to summarize the testimony. As far as whether the testimony was based on sufficient facts or data, Dr. Oleske testified to the various things that she reviewed. She reviewed every medical record, every source of medical records, from Dr. Brown's own clinic, to the ER, to Sacred Heart, to EMS. She reviewed the witness statements. She also, on the data side of things, did her own research and talked to toxicologists and different people. So she had certainly a large amount of facts and data from which she was drawing. She also took some samples of various body parts to be sent off. She did acknowledge she couldn't send all of them off because of Miss Brown being an organ donor. But she did send off some samples that she could. I think she had tissue samples from the brain, the thyroid, the ovary, and the spleen. She asked about biopsy of the organs before they were harvested, but was told why that was not a good idea, and that the surgeons determined the organs were grossly normal, and so they didn't do any microscopic examinations. So there was a lot of data. Certainly there's been a lot made today about the 3.4 blood result. Toxicology is certainly a field for medical examiners to consider, but it is not the only field. I think Dr. Oleske was very candid that she is not a toxicologist. Dr. Borgert was very candid. He is not a medical examiner. Toxicology is a field that is relied upon by medical examiners, but it is not the only field. As far as whether Dr. Oleske's testimony was the product of reliable principles and methods, case law talks about how the process of elimination is valid, ruling out these various things. As to whether she reliably, ruled out these other possible causes, let me set aside complications from lidocaine toxicity. Let's talk about other things it could have been. Let me get to my notes on that. She determined it was not a pulmonary fat emboli. It was not an infection. As best she can tell, it was not a congenital cardiac issue. Again, she couldn't examine the heart, but she did go so far as to find out, okay, the person who got her heart, are they okay? Are they still alive? Are they having any problems? And apparently 6 months after the transplant, everybody who received Mrs. Brown's organs were fine. She said it was not a benzodiazepine overdose. There were no seizure foci in the brain. She even had a neuropathologist look at that. She considered the patient's previous syncopal events. She considered all of these different possible causes and ruled them out. It's not like she just said, lidocaine was given, she had a seizure, she died, therefore that's what it is. She went very far beyond that, ruling out all these other possible causes of death. She also noted that there were no injuries to the major vascular system, there were no perforation sites. At every turn, she was looking at what are other possible causes. Again, she conducted significant research into lidocaine toxicity, complications from those surgical procedures. She looked at the different ways that the lidocaine can be administered, either through a tumescent solution or what she described as subcutaneous injection. She did testify that the rule-out method is common for medical examiners, and we know from case law that it is. I think it was on cross where she said that Mrs. Brown was 33 years old at the time of her death. There was no indication of significant disease, no evidence of infection, no evidence of stroke, and apparently the clinicians who were evaluating her in the hospital also did not see any indications of stroke. No serious trauma or injuries, no evidence of punctures from snakes or venomous creatures, no evidence of an airway compromise, and she did a detailed exam of the neck structures, ruled out manual strangulation. And so there was no other structural reason or cause for the seizure and the cardiac event than what she came back to as, in her view, as the cause of death, complications from lidocaine toxicity. As far as the research that she mentioned, I think I've already gone over that. It was the Basalt textbook. It was the anesthesiology book. It was surgical procedures literature. It was Dr. Susan Eli and Dr. Gill, their book. It was a lecture by Dr. Eli. She called Dr. Eli. She spoke with Dr. Goldberger. She spoke with another toxicologist. And so she is not just making a conclusion blindly and just sticking with it and ignoring everything else. I recognize that Dr. Borgert comes to a different conclusion. He believes that she should have broken it out into the different scenarios more than she did. She said that she considered various scenarios and compared, how would it be different. It sounds like Dr. Borgert thinks she should have gone further and she should have been more meticulous in breaking out the scenarios and then to see, especially is that 3.4 even possible. At the end of the day, I believe that the testimony here today has established that Dr. Oleske had sufficient facts and data. Her principles and methods of how she came to her conclusion are reliable, and she reliably applied those principles and methods. It will be up to the jury to decide which of the two experts to believe. One other thing I wanted to mention, there was a lot about questions of Dr. Oleske and of Dr. Borgert. Was there anything in the records about administering undiluted lidocaine? And the answer is no. Well, I wouldn't expect there to be, because 3 scenarios that I can think of that are unique to when the defendant, the husband of the decedent, is the operating physician. I think there are 3 possible scenarios. One is that he, in fact, did not improperly administer anything. That is possible. Another possibility is he accidentally administered something incorrectly and didn't realize it, to where he truly believes he administered it correctly, so the medical records would reflect he administered it correctly. Or we have to consider the fact these records, although medical records, I don't know that they are clothed with the same reliability as medical records by doctors who are not also the defendant. So there is the third possibility that he realized his mistake but didn't document in the medical records. I don't know which possibility is correct, but I have identified 3 scenarios that are possible. Dr. Borgert seemed to be more believing of the medical records, specifically the ones from Dr. Brown. But I can't ignore the fact that the defendant is the one who wrote them. And so, to some extent, they are self-serving. So, all that, I find that the motion should be denied. The jury should be allowed to hear Dr. Oleske's explanation as to what she did and the conclusion she reached, just as the jury should be allowed to hear from the defense perspective why they think that this conclusion is incorrect. I think this is an issue of weight, not admissibility, and that it's appropriate for the jury to resolve. So respectfully, Mr. Romero, I'm going to deny the motion.
Yes, Your Honor. Is the court going to issue a written order? You want me to draft one, or how do you want to handle it?
I will enter a written order just memorializing the ruling, but I've stated on the record my detailed reasoning, and so I'll just cite, today we had this hearing, I heard this testimony, and for the reasons announced on the record, the motion is denied. I'll file the exhibits with the clerk. We need to set a next court date. There was nothing passed today. This trial is slated for the week of August 17th. Mr. Alderman, from the state's perspective, are we still on track to meet that trial week?
In all candor, Judge, after this motion was filed, we have reached out to a toxicologist to have them review and provide an opinion. I do not have that opinion yet.
Okay. Mr. Romero, from the defense perspective, are we on track for the August 17th trial week?
Not if we're going to have another expert. So quite honestly, if the state's going to present a toxicologist, that will probably delay everything because we will want to hear about it, see a report, depose. Probably we will be bringing in, Dr. Berger may have a place in the trial, but another toxicologist more specific to the issues. I think he was good at procedures and whatnot. So we may be doing the same.
Okay. So it sounds like the week of August 17th is not realistic given
Correct.
a potential new expert witness, which could result in a new defense witness. Obviously, their depositions will need to be taken, and then each side can consider whether Daubert motions are needed for either one of those individuals. So why don't we go ahead and continue this to the next cycle, since we know the August trial is not possible. The next docket day would be October 27th. What's the state's position on that?
I think that's probably reasonable. Hopefully, I think before then we should have an answer and listed a witness, and that would give him time to review everything.
And to be clear, October 27th, I would think, is just a status date. Given the witnesses that'll be involved in this trial, we probably need to pick a trial date fairly far in advance, which if the sides are comfortable, I don't mind going ahead and saying the week of November 16th, which is the trial week for the October 27th date. But I need to make sure both sides think that's reasonable. So, Mr. Alderman, as far as us gearing up for the November trial week with the October docket day, what's the state's position?
I don't know if I'd say reasonable. I'd say possible. As the court is well aware, these, the experts on both sides take time to review, and then, for us to review that information to conduct a intelligent or somewhat intelligent deposition. So I think we can sort of earmark that date, but I would say it's probably ambitious.
Okay. Mr. Romero, what are your thoughts?
I am not in the country on the week of the 16th. It's the only time I'm taking off. So if I could, I'd like to still do that.
Okay. And is that a division trial week, or is that a special trial week?
It's a division trial week.
Division A?
Yes, sir. All right. An added wrinkle in this is I'll be rotating out of Division A criminal come January. And so we will need to discuss whether this case should stay with me, even though I'm no longer in the division. I would need to find out if Judge Stevens would even be able to handle this case, or whether he would have to recuse. He's the person who will be taking over Division A.
Judge, I can tell you that right now, because I was actually out on paternity leave. Judge Stevens actually signed the information.
Okay, well then that answers that. So this case will stay with me even once I rotate.
I'm getting a feeling that Judge Stevens used to be a prosecutor.
He did. He was the prosecutor and supervisor of the Milton State Attorney's
I
Office.
wasn't aware, sorry, but if he signed the information, he probably...
He signed the information.
Okay, thanks.
All right. Well then, why don't we set this for October 27th, and everybody can just update me where we are on that date.
Yes, Your Honor.
This is great.
That will be October 27th at 1:30.
Yes, Your Honor. Thanks for the time and the additional time today.
Yes, sir. You're welcome.